The court requires the attorneys to prepare what is called a Joint Pretrial Stipulation. And that is a very important document because that document is kind of a blueprint that the court has for the case. And it's an agreement that the two parties made through attorneys about what is going to be included in this trial. So, a question is, what is included in a joint pretrial stipulation? The statement of the case is a brief, neutral overview of the dispute about what is the nature of the case. So kind of a summary of what the case is all about. This will help the judge understand, okay, what is this case all about? What are stipulated facts? Number two, we provide stipulated facts. So there might be facts that the attorneys agree upon that are not in dispute. So the more stipulated facts you have in a case, the better to move things along. An example of that, you're dealing with a breach of contract case. The parties can agree that the contract that is attached to the complaint is valid and enforceable, and the parties agree that that's the contract that was signed. So that's a stipulated fact. So the attorneys go through these, and then we go ahead and then the next thing we do is have a list of the uncontested facts. That's where things that we disagree that will have to go to the court. Okay, so you agree on this. This is why you disagree. Whether one party breached the contract, whether the party made the payment or not, whether the services that were agreed upon were delivered. All that is part of an example of something that will be a contested fact, and that will be something that will be presented to the jury or to the judge, depending whether the case is a jury trial or a bench trial. And the exhibit list. So you have the plaintiff's exhibit list, and then you have the defendant's exhibit list. So we provide a list of the exhibits that we intend to use at trial, but the court asks us to do is, to the extent that is possible, agree in which exhibits are joint, meaning that to avoid duplication. And I have a case now that we have nearly, over 1,000 exhibits, when you look at the number of documents. So in order not to present the same document twice, if there are documents that we both agree that, yeah, there's documents that will be used by both of us, then we agree this will be joint exhibits. For example, a contract that both parties sign could be a joint exhibit, so that we don't have two different exhibits with the same information.